In this lesson, we will finish the procedural safeguards and due process. We talked in the previous lesson about the USA OFAC and the United Kingdom's SAMLA 2018. We start this lesson with the European Union. Particularly, we will talk about the key legal mechanisms and case law with EU sanctions law under Article 263 TFEU. The EU sanctions regime provides robust legal avenues for challenging listings, ensures fundamental rights protection, allows for humanitarian exemptions, and is shaped by landmark judicial precedents. 1. Annulment actions. Individuals or entities targeted by EU sanctions may bring an annulment action before the General Court under Article 263 TFEU, but must do so within 2 months of the contested act's publication, notification, or knowledge. To have standing, applicants must demonstrate that the measure is of direct and individual concern to them, as defined by the Plowman test, meaning the act directly affects their legal situation and distinguishes them uniquely from others. The procedure involves filing an application specifying the contested act and legal grounds, after which the court reviews the case and, if successful, annuls the listing as it applies to the applicant. This obliges the EU institution to remove the applicant from the sanctions list and restore their rights, with the possibility of appeal to the Court of Justice on points of law. 2. Legal standards. The General Court reviews sanctions listings on 4 main grounds: lack of competence, procedural error, misuse of powers, and violations of fundamental rights. The court conducts a substantive review to ensure that listings are substantiated by specific and concrete evidence, and that the reasons for listing are adequately disclosed. Fundamental procedural guarantees include the right to be heard and the right to effective judicial protection, as enshrined in Article 47 of the Charter of Fundamental Rights. If these standards are not met, such as when evidence is insufficient or procedural safeguards are ignored, the court may annul the listing, reinforcing the rule of law and judicial oversight in EU sanctions practice. Humanitarian exemptions. EU sanctions regulations provide for humanitarian exemptions and derogations, grounded in Article 215 TFEU and Article 29 TFEU. National competent authorities in each member state are empowered to authorize transactions otherwise prohibited by sanctions, provided they are for humanitarian purposes such as the delivery of essential aid, medical supplies, protective clothing, or other basic needs. For example, Regulation EU No. 36/2012 Syria ensures that food and medical exports are not impeded. Regulation EU 2020 for Hundan 796, Iran allows funds to be made available for humanitarian activities. And Regulation EU 2015-735 Sudan permits travel and export of protective clothing for humanitarian workers. These exemptions are regularly updated to address evolving humanitarian needs and require notification to the European Commission and other member states. 4. Notable precedents. The CADI IC 425p 2008 and CADI 2 joined cases C584-P, C593-P, C595-10-P. 2013 judgments established that EU courts must conduct substantive judicial review of sanctions listings, even when implementing unsecurity council mandates to ensure fundamental rights are protected. More recently, Russian sanctions cases have clarified key aspects. C84-24. The system confirmed that asset freezes can extend to companies controlled by listed persons based on a factual assessment of control. C465-24 SBK held that asset freezes block all rights attached to frozen assets, including voting rights. T573-23. Positive Group PJSC emphasized the need for proportionality and substantiation in listings. And Regulation EU No. 269/2014 codifies a presumption of continued control for listed business persons, placing the burden of proof on the individual to rebut this presumption. To sum up, the EU's legal framework for sanctions ensures meaningful judicial review, procedural fairness, and humanitarian safeguards, with evolving case law reinforcing the protection of fundamental rights and clarifying the scope and application of restrictive measures. We will close this lesson with a few words about cross-border coordination mechanisms. The 2024 OFAC MOU has deepened UK-EU sanctions collaboration through robust information sharing, joint investigations, and regulatory discussions, resulting in the disruption of illicit crypto exchanges and enhanced enforcement. EU Regulation 2018/1805 enables swift, mutual recognition of freezing and confiscation orders, including non-conviction-based across member states, with strict deadlines and limited refusal grounds. Since 2022, this framework, coordinated by Eurojust, has immobilized $280 billion Russian assets, supporting Ukraine.